We're going to go ahead and get started. Welcome to our webinar presentation regarding the new I-9 form and remote verification in COVID flexibilities. I'm Roger Tsai, and we've got Sarah Belletti with us as well. And so today we're going to be talking about this new I-9 form that was recently released on August 1. Recognize many of you are in an in-house counsel or HR role in which you're regularly dealing with I-9s. And so we're going to talk about the new I-9 form first. We're going to walk you through it and kind of point out the distinctions and changes. And then we're also going to talk about this new alternative procedure that permits remote document inspection. And so that's going to go into greater depth in terms of how that is going to work on a day-to-day basis as you are completing that I-9. I want to back up just a tad and just kind of introduce the topic. Many of you which are in an HR role day-to-day, you are completing an I-9 for every new hire or anybody who is rehired. So this obligation has existed since 1986, since the inception of the Immigration Reform and Control Act. And the primary point of all of this is to ensure that there are not undocumented workers that join the US workforce. There are civil fines and criminal penalties associated with the I-9, slightly more than $2,000 per I-9 that is completed incorrectly, and potentially $16,000 for employing somebody who's unlawful to work. Historically, these I-9 forms had to be completed generally in person, and in Section 2, you would confirm as the HR person or HR representative that you had seen original documents, and those documents appear to be, quote, reasonably genuine and related to the individual in Section 1. In the midst of COVID, March 2020, Department of Homeland Security permitted some flexibility for remote workers. And so that remote flexibility existed for roughly 3 or so years. It was set to sunset at the end of July 31st of 2023. And so most recently in the past month or so, Department of Homeland Security has extended this sort of remote verification for certain employers. And we'll talk about kind of which certain employers this applies to. This is a great sort of option for employers, and it's pretty much the largest change within I-9 procedure that has existed within the last decade. Certainly, USCIS and Department of Homeland Security have released new immigration I-9 forms every 2 or so years. So this might be the 5th or 6th iteration within the last decade. But what's fascinating is they are now permitting a broad sweep of remote verification for many employees. I would also note that as part of the incentive or carrot to permit this remote verification, USCIS and Department of Homeland Security are opening this up only to E-Verify participating employers. Today, there's more than 1 million E-Verify participating employers, and they typically filter about 60% of new hires. E-Verify still remains, quote, voluntary at a federal level, although many states do require it at a state level. We'll talk about kind of that expansion of E-Verify in a bit. But I'm going to, at this point, dive right into the new I-9 form. So historically, yes, we had the in-person verification that was required. COVID flexibilities permitted remote verification. So imagine you're viewing somebody through Zoom. They've sent you a PDF of their identity and work authorization documents in advance of that Zoom meeting. And so that was permitted for this period of time. Note that they also, within that same COVID flexibility, required that eventually a secondary inspection would be required. And what was anticipated was that that secondary inspection would be in person. For all practical intents, what was anticipated was that employee who was, let's say, hired back in March of 2020, they were hired in Pennsylvania and your work site was in Salt Lake, and they were rarely coming into the Salt Lake headquarters. But if they ever did come to a physical office, the expectation was that that person would be physically inspected. And so the deadline for that secondary in-person verification was supposed to occur August 30th, 2023, so just at the end of this month. So that was kind of the general expectation that at some point you would see this person in person and take a look at their documents and compare them versus the person before you. Employers must do this even if operating fully remotely now. So even if you were operating completely 100% remotely, this obligation to conduct this secondary verification is still in place. Although there's this alternative of using a quote authorized representative or somebody you delegate to complete Section 2 of the I-9. As part of this sort of additional verification in person, there was not the need to complete a new E-Verify case or re-verification. So you'll note on here within the I-9 form, Section 2 here, there's this additional information, remote inspection completed on 3/30/2020, and then COVID-19 document physically examined on X date by X individual. So that was kind of the note that would occur typically in this additional information section within Section 2 upon that secondary verification. Sarah, I'll pause and see if you want to add anything there.
I think the one thing I would note that I've been asked questions about by employers since all of this has happened in the last 2 months about physically inspecting documents that were examined remotely during COVID flexibilities, particularly for employers that are not E-Verify and don't have the option to use the alternative procedure, is you'll see in this example graphic that we have what this note is supposed to look like that Roger just mentioned. And for the COVID-19 document physically inspected on date, you see it says by AA, which corresponds to Abigail Adams, which is the person who signed it below. If it's not the same person who does this secondary inspection, they should write their full name.
Good point. Thank you. So within Section 1, the employer must make complete instructions to the I-9 form available to the newly hired employee. Just as a reminder, often, certainly employees may not require that or may need to, they may understand kind of generally how to complete it. Note that the employee must complete and sign Section 1 of the I-9 no later than their first day of employment. And that's a reminder that exists both on the old form and the new form that was recently released on August 1. The first day of employment is the actual commencement of employment for wages or other remuneration. So just as an example, for example, if you had somebody who was, before they actually began work, they had a first day of training, let's say, and within that training, they're getting compensated. That technically is their first day of employment. Employee may complete Section 1 of the I-9 before his or her first day if they've accepted the job offer. So many employers have asked the question of, can I use the I-9 to basically filter out individuals who I worry are not lawful to work in the United States, and before I even offer them a job? And the answer to that is broadly no, you cannot use the I-9 as a filtering tool before you have offered the job to the candidate and that candidate has accepted the offer. There's a number of discriminatory reasons why that is the case, but it's just something to keep in mind. So here's the old version of the I-9, and many of you are familiar with this. This has been in place for a number of years. The things that I am noting, I guess, so the information here, it generally should align with the identity documents and employment authorization documents. There are instances where somebody's name may have changed, or anyways, you might have names that don't quite match, but anyways, it's something that you want to pay attention to. If you do have two documents that contradict each other, for instance, in name, I would go off of the Social Security card if at all possible. You'll note within this older version, you've got 4 choices in terms of what the new hire is going to check off. So we've got citizen, non-citizen, national, lawful permanent resident, and alien temporarily authorized to work in the United States. And that new hires checking one of these options based on penalty of perjury. Those options have been slightly tweaked and the verbiage has changed ever so slightly. Certainly, once again, the employee must sign. For those who are completing this form electronically through, anyways, an electronic I-9 system, there is a regulation that was issued back in 2010. Anyways, if you are not using a major vendor for electronic I-9 completion, just it would be worth just double checking if your electronic I-9 procedures are consistent with that 2010 Department of Homeland Security regulation in terms of electronic completion. Note that just simply like, for example, PDFing a copy of an I-9 and storing it may not meet those 2010 regulations. So it's worth taking a look there. So this is the top half of section of the new I-9. And so what has happened is all the questions should still be there, and all the content that has been requested in the old I-9 should still be within this new I-9 form. It's been slightly reformatted, so you might feel like things are kind of mixed around in slightly different places, but the overall content is fairly similar, if not almost identical. Here are a couple of things that I'm noticing within the changes. Note that at the very top, they have a link to the instructions. Those instructions have been newly crafted. They've shrunk down from 15 pages to 8 pages. So it's worth just taking a read through those instructions just to kind of reorient yourself. I would note for those who are really, really deep into sort of I-9 knowledge, there's two other sources of information. There's something called the M274 Guide to the I-9, which has existed for roughly 15 years. And then there's also something called I-9 Central. And so both of those are shared through the U.S. Citizenship and Immigration Service, and certainly a point of just information that you can take a look at. Within the Section 1 boxes, you'll notice that generally the same information is requested. Note that the Social Security number is mandatory if you are an E-Verify participating employer. And so that, anyways, is more important. I would also note that the admonition here, on the left-hand side here, has a box that says, I'm aware of that federal law provides for imprisonment and or fines for false statements or the use of false documents in connection with the completion of this form. So that language is much stronger, and I have a sense of why they've made that a bit more of a warning or admonition. I attest under penalty of perjury that this information, including the selection of this box attesting to my citizenship or immigration status, is true and correct. So you'll note that the four options now here, U.S. citizen, or sorry, citizen of the United States, number one, that's the same. Non-citizen national of the United States, that is a fairly rare option that many people don't check. Individuals coming from certain U.S. territories like America Samoa are considered non-citizen nationals. And that's further elaborated within those instructions. Lawful permanent resident, that's synonymous with a green card holder, essentially, somebody who's a permanent resident. Typically, those cards are issued for a 10-year period of time, except in instances where somebody's in a new marriage, and those are issued for a 2-year period of time. Note that if they do, in fact, have a permanent resident, if they are a lawful permanent resident, then they would indicate the USCIS or A number, which is short for alien number. And then the last box here, somebody who is a non-citizen authorized to work for a certain period of time until basically a set expiration date. And so this is a catch-all for a wide variety of different immigration status, including asylees, refugees, certain individuals who might be international student graduates under F1 OPT or STEM OPT, may include the alphabet soup of different work visas like H-1Bs or Ls. So those are all potential options for those non-citizen nationals. Note that if you're checking, new hires checking that last box, anyways, they would provide one of the following pieces of information. So USCIS alien number, something called an I-94 admission number. So the I-94 is created by U.S. Customs and Border Protection, typically upon the arrival of somebody's entry into the United States. typically those records can be accessed electronically or online on the US Customs and Border Protection website. And then, or lastly, the foreign passport number and country of issuance. Noting that, once again, the employee is going to sign that and date it. Typically, what would immediately follow this section is a preparer or translator section. And so that is no longer the case, and that information has been moved to, addendum A, I believe. So that is moved to a different page, recognizing that most new hires are probably not going to have somebody who is a preparer or translator. So I'm gonna, let's see. So this is the larger form, just to kind of view it in totality. So let's see here. So just a couple of like quick changes, and I've mentioned some of these already. So it's now a single-sided sheet. The American Immigration Lawyers Association did indicate that they were slightly concerned that it is a single sheet, and some employees may go ahead and complete section 2 by accident. It's designed to be fillable on tablets and mobile devices. We talked about the fact that the prepare translator section has been moved to supplement A, and it's not necessary to retain that document if it's not completed. So if there is no preparer translator, you don't have to keep or retain supplement A. Section 3, so that would have typically been the rehire and re-verification section. That's in a standalone supplement B that employers can print and use when there's a rehire that occurs or re-verification. Note that that can also apply to name changes. Let's say somebody got married and anyways, they have a name change and they have a new document that shows that anyways, they have a new name. There's also a slight revision of the list of acceptable documents, which Sarah will go in greater depth to include some acceptable receipts of like USCIS type receipts and guidance regarding automatic extensions of work authorization. It includes a checkbox allowing employers to indicate they've examined the I-9 documentation remotely under the new DHS authorized procedure, alternative procedure. So bottom line, if you've done some sort of Zoom verification, anyways, there's a new checkbox, which Sarah will cover in section 2. These are just kind of as the employee is going through the I-9 section 1, this is what they're responsible for. So completing the full legal name, including other legal names that might be used, like maiden names, excuse me, including a full address, date of birth, social security number, appropriate option for immigration or citizenship status. So we talked about those 4 options and how there's been a slight tweak in the name. If they check the non-citizen national to work, they need to include one of the following: the alien number, I-94, or foreign passport number, the signature and date, and including the email, telephone number is in fact optional. I think that's been the case in the last 3 or so I-9 forms. The translator preparer section is once again optional within supplement A. And then last reminders here. These are just kind of our tips here. Review to ensure that the employee completed all necessary fields. So I would never take or presume that the new hire has completed this properly. And certainly you want to double check, like they've signed the appropriate date, that their information matches the identity and work authorization documents. We talked about the translator and preparer section, if that's in fact relevant and necessary in this particular case. Check whether the employee indicated that their employment authorization would expire. This is critical. A lot of employers, I know many of you are just, you've got a ton of US citizens. And anyway, somebody's giving you a driver's license, social security card, and occasionally in a rare day, you might have somebody who has that non-citizen national status and their ability to work in the United States to expire. It's critical that you keep track of that in some meaningful way within your HRIS system. And typically you'd want to remind the immigrant employee of that expiration 90 days prior to, and certainly probably have a dialogue to just understand, has an extension process been started? Is there some sort of auto extension policy that's upcoming just to avoid any disruptions in that person's ability to work? The employee must provide updated documents on or before the date of their current expiration of work authorization, unless that auto extension applies. For those of you who are deep in the weeds in terms of I-9 process and procedure, you know that this can get super nitty gritty. That, just as an example, that M274 guide to the I-9 when it was in paper format was 60 pages. So it's like, anyways, it's a 60-page guide on how to complete a 1 to 2-page form. So anyways, it can get fairly complicated. I'm going to turn it over to Sarah to talk about section 2.
Great, thank you. One thing I would add just before we wrap up section 1 is Roger mentioned it's very important as the employee completes section 1 to make sure you as the employer are reviewing it, that everything is completed and as complete as possible and accurate. Because in the event of an internal audit, if the employer is conducting its own, or in the event of a DHS audit where you're trying to make corrections, only the employee can correct section 1 because it's up to them to fill that out. So it's all the more important that that's correct, because if the employee has since departed, you won't be able to then correct those issues if you're providing an I-94 as part of an audit that's still within the retention period. So it's pretty vital to really review that section 1 and have employees make any updates or additions or changes in real time. But moving to section 2, so Roger also noted with the new form, USCIS has collapsed section 1 and section 2 onto one page, which I think is going to be somewhat confusing. I think the reason it was separated into 2 previously is because the employee completes section 1 and the employer is responsible for completing section 2. Now it's going to have to be probably clear directions are going to have to be given to employees to make sure they just complete section 1 and then section 2 is completed by the employer or the employer's authorized representative. As the employer, you or your authorized representative must complete and sign section 2 of the I-94 within 3 business days of the date of hire of your employee. And the hire date means the first day of work for pay. So as an example, if your employee began work for you on Monday, you must complete section 2 by Thursday of that week. And that's one of the biggest things I see not happening when I have done audits of an employer's I-9s before, and that's a process violation, so it's not correctable. And so that would be finable if it's not done within the appropriate period of time. So something to really pay attention to. Another kind of note is if the job lasts less than 3 days, you must complete section 2 no later than the first day of work for pay. That's a pretty unusual situation, but something to be aware of because it is an exception. The employee also has responsibilities for section 2, which is namely to provide acceptable documents, which can either be one document from list A or a document from list B in combination with one document from list C. And the reason for that is List A documents prove both identity and employment authorization, whereas List B proves only identity and List C proves only employment authorization. So the employee has the option to provide one document from List A or a combination of one document from List B and List C together. As the employer, you're examining those documents to make sure they look original, they're acceptable, they're listed as an acceptable document on the I-9 form list and unexpired, and show the identity of the person and it matches what they listed in section 1. In certain cases, employees can also present acceptable receipt notices for list A, B, or C documents. And as Roger noted in the updated list of acceptable documents, they have included some new sort of elaboration of what those receipt notices are that is helpful. If you participate in E-Verify, another important thing to note is if the employee presents a combination of List B and List C documents, then the List B document that proves identity must contain a photograph. The employer or authorized representative must ensure that any document your employee presents from the list of acceptable documents is original, except that certified copies of birth certificates are acceptable. Same thing with the receipt notice. You must examine the documents to determine if it reasonably appears to be genuine and relates to your employee presenting it. And for the most part, as we've discussed, The employer must physically examine these documents with the exception that for hires after August 1st of 2023, if you are an E-Verify participating employer, you have the option to pursue this alternative procedure and check this box on section 2 in the additional information section. We'll talk more about that in a bit. If you are not an E-Verify employer, then you must physically examine the documents for individuals hired after August 1st, 2023. And for individuals that had the COVID flexibilities that were hired between March 2020 and July 31st of 2023, you have the obligation to do that secondary physical inspection of documents, which Roger mentioned. Another thing that I think often trips up employers, and is something I see as an issue when I'm auditing I-9s, is the date that's listed that the employee began employment. So this can be a current date, meaning the date that the form is completed, a past date, or a future date. So you should enter the current date, like the date the employee is completing it, if it's the same day your employee begins employment for wages. It can be a past date in section 2 if your employee began employment for wages. So you should enter the actual day they started if you're completing the form after the fact. That can be a violation, but you still have to list the day that the person actually began. It can also be a future date if section 2 is completed after the employee accepts the job offer, but before he or she will begin employment for wages. So the moral of the story is the date that's entered there has to be the day the employee started for wages. Let's see. One other important thing to note is employers may not enter a PO box as their address in section 2. If your company has multiple locations, use the most appropriate address that identifies the location of the employer with respect to the employee in their Form I-9 completion. For example, the address where Form I-9 is completed, like where the employee is working. And then once you complete section 2 and the either HR representative or authorized representative designated by the employer has signed and dated section 2, you have to return the original documents to the employee. I often get asked questions too about retaining copies of documents. You can choose to retain copies of documents or not, or you could have been retaining copies and choose to stop that practice, but you have to be consistent. So either you have to do it for everyone, or if you choose to stop, you have to stop for everyone, with the exception that with this new alternative procedure for E-Verify employees that are using the remote document inspection, they have to retain copies of the documents that are examined remotely. Okay, moving on to supplement A. Roger mentioned this before. This is where they have now moved the preparer translator certification section. I don't think it's all that common for an employee to use a preparer or translator to complete Form I-9, but it could happen if their English isn't good or perhaps their reading and writing skills aren't up to par. And it could be two separate individuals. It could be someone that helped them prepare the form and then also a different translator. I think that would be pretty unusual as well. But if they are using some assistance to complete the Form I-9, then the individuals that are assisting have to complete this section. And if you have to re-verify, for example, if they mark in section 1 that they're a non-immigrant worker and they have an expiration date, when you go to re-verify, if they're again using a translator or preparer, that person has to fill out one of the additional boxes within the supplement A. Let me pause there for a second. Roger, did you have anything you wanted to add up to this point?
Excellent points. I would just what's fascinating about this supplement A, like they give you multiple opportunities to list multiple like translators and preparers, and we were just kind of a little puzzled as to like why there would be so many multiple preparers and translators, especially if you're just kind of more or less completing this once. Yeah, I think what I note is like if you're going to complete this section, often what's missed is this like at the very top, the last name, first name, middle initial, just to kind of help to tie this to the I-9 document itself. If you're keeping this in paper, just figure out a way to attach this so it doesn't get lost, because it's going to be one of these weird and exceptional instances where you actually do have a supplement A. Yeah, excellent points on anyways, section 2. And yeah, I'll let you kind of continue forward.
Thank you. One other thing I would note about supplement A is if the employee is using a translator or preparer, the date that the translator or preparer is dating their certification should match the date that the employee is indicating in section 1. Well, that's supposed to happen at the same time. Okay, supplement B. This is formerly section 3 of the previous I-94, and this is where things get a little more in the weeds. Um, section or supplement B, I'm sorry, is can be used for employers, well, must be used for re-verification when they have an employee whose employment authorization expires. And it may be used by employers when they've rehired an employee within 3 years of the date that they completed their initial I-9 form, or if your employee has a legal name change. Um, when completing supplement B, the employer must also complete the last name, first name, and middle initial fields at the top of the page that you'll see right here at the top of this new supplement. That's important. I see that left blank often, not in this new form because I haven't been reviewing those yet, but in the previous version that was often left blank. For re-verification, when an employee's employment authorization documentation expires, you must re-verify to ensure that they're still authorized to work in the US. To confirm the date your employee's employment authorization expires, you should review section 1 for the date that employment authorization expires that they indicated, but you should also review section 2 for the date that the employment authorization document that you examined expires, and you should go by the earlier of those two dates in terms of re-verification, because section 1 may not match the document expiration date recorded under list A or list C in section 2. You must re-verify by the earlier date when re-verification is necessary, and we suggest that you remind employees at least 90 days before the date re-verification is required that they will be required to present a new List A or List C document or acceptable receipt notice showing continued employment authorization on the date that their employment authorization expires, or sooner if they have it sooner. Employers should not re-verify US citizens and non-citizen nationals. So Roger mentioned non-citizen nationals would be someone who's a national of a territory like US Samoa. Lawful permanent residents also shouldn't be re-verified. This one can be very confusing because green cards carry expiration dates. However, they are not to be re-verified because under US law, once you become a legal permanent resident, you have that status unless and until a US immigration judge takes it away. So that can be very tricky because I know that expiration date is there, but a legal permanent resident is a legal permanent resident unless that's stripped from them through a legal proceeding. The other thing that you don't re-verify is List B identity documents. Once the person has established their identity, you don't have to re-verify that. Another note about this re-verification section 3 is receipts for lost, stolen, or damaged documents can be acceptable for re-verification. If those are presented, they're usually only valid for re-verification for 90 days. And then sometime before that 90-day period is up, the employee is supposed to present their, renewed document that hopefully they've gotten if it was lost, damaged, or stolen. So on this form, similar to section 2, you're recording the document title, the document number, its expiration date, and then you're putting in the name of the employer authorized representative, signing and dating. There's also a checkbox here within supplement B that you can click if you are using the alternative procedure for remote verification if you're an E-Verify employer. So that's an important change. For rehires, if you rehire your employee within 3 years of the date that the previous form I-9 was completed, you may either complete a new I-9 form for the employee or complete supplement B of the previously completed I-9. To complete supplement B for rehires, you must confirm that their original I-9 relates back to that same person and review it to determine if the employee is still authorized to work. If they're still authorized to work, like for example, if they presented a List A document like a US passport, then no real re-verification of employment documentation is needed. You would just fill out, you would just, put the individual's name and sign and date. If what they presented previously to show their employment authorization has expired, then it would be similar to this example here where you would have to examine new employment authorization documentation and indicate the new expiration date as well. Let me pause there for a second. Roger, anything to add to that section?
The Within this, rehire, re-verification, name change, I would note that typically this does not trigger like a new e-verify type obligation. Um, anyways, that I think also the other question is like if you have somebody who comes back seasonally, how do you kind of complete section 3 again and again and again? And so generally, one would complete those again. Um, the we had a follow-up question regarding just like permanent resident cards and sort of the need for re-verification. And I just wanted to clarify, and Sarah's exactly right. So the permanent resident card or green card does not need to be re-verified, whether that is the 2-year permanent resident card or the 10-year permanent resident card. So the 2-year permanent resident card is typically given to somebody who's in a new marriage to a US citizen. And so anyways, neither of those need to be re-verified, but upon the completion of the I-9, those documents must be unexpired at that time. And that applies to like, all documents received for I-9 purposes, right? So that applies to US passport, applies to driver's licenses, whatnot. Yeah. Once again, the major sort of failure point within, I guess, Section 3 or re-verifications is just simply knowing your employees and who has some like a work authorization that may expire. And once again, it can get super, super complicated, particularly with some of these auto extension rules. There's a 180-day auto extension rule. There's a 540-day auto extension rule. There are some instances where if somebody has filed an application, they have continuing work authorization for a certain period of time. So that's 180 days if they're under F1 status. It can also apply to H-1Bs if they have a pending H-1B extension. But in short, it gets a little complicated. The M274 guide to the I-9 may be helpful. In addition, we can be helpful as well.
Great, thank you. I think we got a couple of more follow-up questions. We have one that says clarifying question, should we be doing section 3 for all name changes? I would say as a best practice as the employer, if you're aware of the legal name change, then yes. And I would think how this would come up normally is if someone has a legal name change, they're going to notify you because they're going to want to have it updated for payroll purposes. And at that point, if you're on notice of it, it would be a good idea to do supplement B and reflect the name change. Do you have thoughts, Roger?
Yeah, I think you're right. I think sometimes employees may not offer that information, but like when in the course of an ICE audit and investigation, they're going to exactly do as Sarah mentioned. They're going to ask for your payroll records and compare those to your I-9 records. So best course of action would be to internally audit your I-9s. And if you have thousands of employees, maybe you choose to just do like a 10%, but you'd want to double check like one, do we have I-9s for all of our active employees? And two, do those names match up? And if they don't match up, then anyways, we may need to do that sort of section 3 update. Let's see,
Great.
let's see, Sarah, do you want to keep going or do you want to address this one other question?
I was going to address that too. So the other question we got is what if the employee has lost their acceptable documents provided on their first day when the time comes for the in-person inspection and they do not have a replacement? So I would say that receipts for lost, stolen, or damaged documents are acceptable for re-verification. So this person would at least have to have a receipt notice that they're in the process of replacing whatever it is that's lost, damaged, or stolen, because the re-verification has to happen, and ideally it needs to happen before August 30th. That's the deadline for this to occur. So they should hopefully be able to provide at least a receipt notice for the lost, damaged, or stolen item before then. What, Roger, what do you think?
Absolutely, fully agree. The only, and I would just add, the documents that they showed upon their initial completion of the I-9 Section 2, anyways, those don't have to be the same documents that are shown upon, anyways, Section 3 re-verification. So if their immigration status is somehow changed or they have a different immigration document, certainly acceptable. The key sort of rule to keep in the back of your mind is it is the employee's choice as to which documents they choose to provide. And I would also note it is considered, it's a violation, otherwise known as document abuse, if you ask for more documents than are necessary to go through the I-9 process. So as Sarah had mentioned, you only need a List A document, right, which shows identity and work authorization, or a List B and C document, which show identity and work authorization separately. If you ask for all the above, that's a problem. So anyways, just don't do it. Um,
Exactly.
Sarah, do you want to talk about kind of the acceptable documents and
Yes, and I'm going to go through this a little faster just because we're running out of time and we have some more interesting things to cover. But
sure.
this is the updated acceptable documents part of the new I-9 form. And I'll just point out some interesting things here that are different. They have changed the format a little bit, and I think they've made this somewhat easier, hopefully, for employers in the sense, if you see number 7 here under List C, it gives you some references to where you can go look to see if a List C document is acceptable, because there are more odd List C documents than either of the other categories, and it can be the most challenging to figure out if what the employee gave you is acceptable for that purpose. So it refers you to I-9 Central, which I put the link in our chat as well, which has a lot of good information about what is acceptable in terms of documents that you can go look at examples as well. Um, you can always also reach out to us if you have specific questions about any of this, and we're happy to try and kind of unwind it for you. At the bottom here, there's also this new section that says acceptable receipts. And this refers essentially to United States Citizenship and Immigration Services receipt notices, which often at the top will say I-797. And it gives some information on what's acceptable in each of those categories in terms of receipts. But there is more information and examples in the M274 manual and also at I-9 Central that I would encourage everyone to take a look at. And then if we can go to the next slide. This is sort of just a quick kind of lead into the different documents. So as we talked about, List A documents prove identity and employment authorization. And those are basically things that show you're a US citizen or a legal permanent resident of the US, such as a US passport or a legal permanent resident card. And then for individuals who are non-immigrants, like workers or visitors, the most common of which are probably H-1B visa holders that you may see, um, they're they're typically providing either List A documents that are a combination of an I-94 and a foreign passport. And if you see this white card in the lower right hand right here, that's an example of a paper I-94. And as Roger mentioned, those aren't given out too often anymore by Customs and Border Protection. They've gone electronic, but we can typically pull the individual's I-94 record off CBP's website by entering some of their passport information. And as employers, you can do that too. CBP website's available to everyone. And if you want to check someone's I-94, that's a possibility. If we go to the next slide. For List A documents, as I mentioned, the primary ones are a US passport or a legal permanent resident card. There are some more unusual um, things that are possible. One that I get asked about every once in a while that like employers tend to kind of freak out over, don't know how to deal with, is people who present a passport from the Federated States of Micronesia, the Republic of the Marshall Islands, or Palau. And that's sort of a special case where the US has certain treaties in place. And for those individuals, often their unexpired passport from that place plus an I-94 will be sufficient as a List A document, but you have to include both documents within List A on in section 2 of the I-9. But if you get something like that, again, feel free to reach out. It's an unusual case. And then if we can move on to List B are documents that establish identity, and you'll see here a list of a bunch of acceptable common List B documents, the most common of which is a driver's license. Other things that are acceptable are a military ID, a voter registration card, more unusual Native American tribal document, and also driver's license issued by a Canadian government authority, all acceptable. If the person is a minor, they can provide a school record or report card, a or even a record from a clinic or doctor or hospital record. Or this last one is new, and Roger and I were both kind of puzzling over it because it was daycare and nursery school record. And it seems unbelievable to me that that's what someone would be providing, but maybe if they're, 15 or 16 years old, and that may be all they have. So that is now also considered an acceptable List B document. And then moving on to List C. List C documents, again, are documents that only establish employment authorization. So the most common one that I see on most I-9s is a US Social Security card, but there are many other possibilities. One thing to note in particular about a Social Security card is if someone presents you a Social Security card that has a notation on it that says not valid for employment or valid for work only with INS authorization or DHS authorization, those are not valid for List C documents because it has this limitation. And typically what that means is maybe the person is authorized to work only for a specific employer, or there are other limitations on their employment authorization that may not, it's not an unrestricted right to work in the US. Other kind of acceptable documents include a consular report of birth abroad or a certification of birth abroad. Again, a Native American tribal document can be acceptable. And then if we go on to the next slide, where this really gets complicated are certain I-94 arrival departure records for individuals that are maybe in the US as asylees, or individuals who are in H-1B non-immigrant status or other non-immigrant work authorized statuses. And then there are some other even more unusual things such as refugees that have this form I-571 refugee travel permit or an unexpired I-327 reentry permit. And I don't think I've actually ever seen someone use a form N560 or N550, but that's a certificate of naturalization or US citizenship. And Roger, if you'll go to the next slide, I think we have an example of a refugee permit. Yep, this right here is an example of what someone may present, this travel document for List C purposes, and that is acceptable. And you'll see it says right here, reentry permit form I-327, refugee travel document form I-571. And these will remain valid until the expiration date on the travel document for List C purposes. Okay. And then where this gets yet more complicated, as Roger had mentioned earlier, that there are certain classes of employment authorization documents that are eligible for auto extension of employment authorization if the person has timely filed a request for renewal and if the category on their expired employment authorization document matches the category on their I-797 receipt notice that they're presenting, with the one exception that for TPS, it can be two different categories. So on I-9 Central and USCIS.gov, there's a list of all of the EAD categories that are eligible for auto extension. You'll see them here. This is a snip of that. The ones I think that most employers are maybe likely to see are people H4 dependents of H1B non-immigrants, or L2 dependents of L1A or L1B non-immigrants. You'll see that's here A18. That's sort of complicated though for L2 and H1B spouses. They also have to have an unexpired I-94. So the moral of that story is typically auto extension doesn't work for them. But for many of these other categories it can, such as the refugees, asylees, citizens of Micronesia, Marshall Islands, and Palau. And there are several other kind of more unusual situations that are listed here. Roger, anything to add to this?
No, this is great. I'm going to let you keep going just in interest of time.
Yes. Yes, we are running out of time. We need to speed up here a little bit. So this is again sort of just sort of like key takeaways about automatic extensions. I would say though that in general, because this is so complicated, if you're unsure, reference I-9 Central, and they do have a tool on there that's EAD Auto Extension Calculator, where you can input some information from your individual and it can kind of confirm for you what their period of auto extension is. Or I also encourage people to reach out to, one of us or another immigration attorney to check because this is very complicated. Okay, and moving on. So here's sort of the most important thing about what we're talking about today. So on July 31st, 2023, the I-9 related COVID flexibilities ended for remote document inspection, as Roger mentioned. And individual or employers who are not E-Verify and don't qualify for the new alternative procedure must do an in-person inspection of documents before August 30th of 2023. And if not, they would be potentially subject to fines and penalties if they were audited by Immigration and Customs Enforcement. Employers must do this even though they're operating fully remotely now, but they can utilize an authorized representative for physical inspection. And they should not create a new E-Verify case or re-verify employees in connection with this physical inspection. As we mentioned, there are certain qualified employers who utilize E-Verify who can now use the alternative procedure, but we'll talk more about that in a moment. And then this is kind of a repeat of the same one. But again, this is an example of a notation of a I-9, the older version, not the one that came out on August 1st of this year, about what employers should be noting in Section 2 in this additional information box regarding this in-person inspection of documents. And then Roger, did you want to talk
Yeah.
about this part?
Sure. So the remote verification sort of option, right? This is only possible for certain employers. And USCIS DHS has been very clear. So number one, are you enrolled in E-Verify right now? So you need to be enrolled in E-Verify. If you're going to use it for that secondary verification, you must have used E-Verify at the time that you as an employer performed the remote examination of the employee's I-9 under COVID flexibilities, right? So if you're trying to do that secondary verification before August 30th of 2023, and you want to do that remotely, you must have been using E-Verify at the point that that initial I-9 was completed from March 2020 to July of 2023. And anyways, and perform the remote inspection between March 2020 and July 31st. Okay, so this remote verification is only available for E-Verify participating employers. And I would note that Department of Homeland Security has issued a proposed federal register announcement that they are considering a pilot program to expand this sort of remote verification to non-E-Verify participating employers. So it may expand even further than just simply E-Verify participating employers. That has not occurred, but it may. We believe, anyways, and within kind of the DHS announcement, they're limiting it to E-Verify for two primary reasons, because number one, E-Verify has this photo tool component. So basically, as many of you who use E-Verify are familiar with, every time you have a permanent resident card, employment authorization card, or other USCIS, DHS issued document, anyways, that picture will pop up. And within the E-Verify system, that information that they call from typically is cross-checked with the Social Security Administration. So the likelihood or the potential of using a quote fraudulent Social Security number is more limited. All this being said, I know a lot of employers that are using E-Verify and we're doing remote verification. I think the bigger policy question that HR folks and employers should be thinking about is E-Verify, once again, is not bulletproof. If somebody has a really good fake document which steals a real person's identity, you can get through E-Verify. They had my real date of birth, real Social Security number, and their picture on a driver's license, they can get through E-Verify. And so I think as part of this remote verification, your ability to touch and feel those documents is going to be reduced. And even if you're using E-Verify, do not take that as an absolute, I guess, certainty that somebody's lawful to work. Just keep your antenna up. So we recognize this is slightly confusing material. And so we wanted to kind of break this down. The major question here is, are you using E-Verify or are you not using E-Verify, right? So I think this hopefully should be one of the more helpful slides, which Sarah helped to create. So number one, if you're using E-Verify, then you may use remote verification on COVID flexibility completed I-9 forms that were done between March 2020 and July 2023. You also may use remote verification, this alternative procedure, on future new hires after August 1 of 2023. So those are two instances where you can use this new like Zoom-based sort of confirmation of identity and work authorization documents. You must consistently implement this remote verification procedure. You can't pick and choose. That being said, so you can use it on all new hires and built within the regulations, they said, or you can use it on all remotely hired employees. But you can't use it on like, I don't know, employees A through J, or anybody who checks non-citizen non-citizen alien temporarily authorized to work, essentially. So you can't use it in such a way to be selective. All right, So what do you do if you're not using E-Verify? In those instances, you must use in-person secondary document verification before August 31st of 2023. So that means you are meeting with the person, you are looking at the document and their driver's license, social security card, and comparing it to that person. You may not use remote verification on COVID flexibility completed I-9 forms. So you're not using E-Verify, you don't get this benefit that they're allocating. You may not use remote verification, this alternative procedure, on future new hires after August 1st of 2023, unless you register for E-Verify. As mentioned before, they're thinking about expanding kind of this remote verification to non-E-Verify participating employers, but that is not the case presently. And Sarah's going to talk about this kind of mechanically how this would work.
Yeah, so the new virtual document inspection procedure, what is it, right? So basically what it requires if you're an E-Verify employer and you qualify to utilize it, you would have your employee send you their documents in advance so that you can inspect them. Then you conduct a live video interaction with the individual presenting the documents to ensure that the documentation reasonably appears to be genuine and relates to that individual. And then you retain a clear and legible copy of the documentation that was provided front and back if the documentation is two-sided. And on the I-9 in section 2 for the new form, you're going to check the box that says you utilized an alternative procedure authorized by DHS to examine documents. If you are going through like re-examination of COVID flexibility completed I-9s, but that were between March 2020 and July 2023, it will likely be on this older version of the I-9. It would have to be, and that doesn't have that checkbox. So instead, you would just indicate alternative procedures, live video inspection, the date it was conducted, and this is, as they said, this is an example of just one possible option for use, but this is a good one to follow because it comes right from United States Citizenship and Immigration Services. Okay.
So these were some FAQs offered through the American Immigration Lawyers Association. So can we use remote verification alternative procedure only on some employees? The answer is maybe. And so yes, in situations like you're using it on just your remotely hired individuals, that is permissible. Once again, cannot use it on certain immigration types, certain individuals who, for whatever reason, seem suspect. Note E-Verify is similar in policy. Once you register for E-Verify, you have to use it on all new hires, regardless of who they are, where they're being hired. There are some exceptions to what I just said, but it gets into some minutia, like federal contractors. What if new hires wants to use the normal in-person I-9 verification process? So let's say somebody doesn't want to jump on a Zoom, they just want to look at you and share their driver's license and social security card with you. That's perfectly fine. That is their choice. We cannot force like the Zoom or alternative verification process upon them. If an employer enrolls in E-Verify now, can we use the alternative procedure virtual review to update the COVID-related I-9s? And the answer there is no, you cannot, because the COVID I-9 completed, the I-9 completed in the midst of the COVID flexibilities. Your company was not using E-Verify at that time and therefore does not satisfy the requirement to go through that alternative procedure for this secondary verification. Here are the quick important dates, right? So if you've got some I-9s that were completed with the COVID flexibility, basically with remote verification, anyways, that ended as of July 31st of 2023. So you can't do that anymore for COVID purposes. And if you do have any of those I-9s, you've got to do this secondary document review that must occur for COVID I-9 forms where remote verification was used. So that has to be done by the end of this month, August 31st. Note, that might be by Zoom or in person, depending on whether or not you use E-Verify. And then August 1st, we of course have this new I-9 form that was introduced. I think it's a good idea to start, sharing this with your HR teams if you haven't already looked at this. Get familiar, get comfortable with it. November 1, 2023 is when you must begin using the new I-9 form dated 8/1 of 2023. So anyways, this is a good time to kind of flesh out those questions that might come. I would note, this new I-9 form does not sync or auto-populate with E-Verify. So if you're using some sort of electronic I-9 completion, or if you've got a vendor that's facilitating E-Verify, this is a good time to kind of flesh out any of those potential technical bugs or transitional issues. And then I think, Sarah, you were going to talk about authorized representatives.
Yes, and we're running out of time, so I think maybe we'll address the questions that we have because it touches on some of the slides we're going through so that we can get to this, which is probably more interesting to all of you than our slides. So one of the questions I got deals with this: remote employee living out of state, can they have a notary verify their I-9 IDs? So this is a good example of you can utilize that notary as an authorized representative if they're willing to act in that capacity. If you want to do so and this notary completes section 2 of the I-9 and makes a note to update that physical inspection of documents has been completed, then that person should first of all list their full name. They should not place a seal on the I-9 because they're not acting in their capacity as a notary. They're acting in the capacity as an authorized representative of the employer. And whoever you choose as an employer to act as an authorized representative, the most important thing to note is that the employer assumes liability for any errors in the I-9 form or the process in which it's completed itself. So if you're using an authorized representative, my advice to our clients is always make sure you're reviewing the whatever is being completed in real time. So if any corrections or revisions need to be made, you can have that done right there on the spot, rather than if you look at it later, it might be too late to make corrections or changes to what's been done on the I-9 form. I think, let me see what else we have here.
There was
Um,
Lindsay had asked the question of if a document is used during COVID and that document has since expired, let's say it's like an EAD or work permit, how do you handle that with alternative procedure? Bottom line is whatever documents they're going to show you now need to be updated within that, I'm sorry, unexpired within that alternative procedure. So same rules apply when they present the documents, they need to be unexpired. Sarah, I don't know. Go ahead.
I agree. Yes, I agree. The person has to present valid List C documents at this time, and they should be able to do so. It doesn't have to, and you can't dictate it that it be the same thing. They could present another valid List C document. It's up to them, but it's got to be valid for this purpose as well. We also have a question that says, if we are an E-Verify employer and have been remotely verifying from March of 2020, now do we have to go back and re-verify? In terms of doing a secondary inspection of documents that were remotely verified as for the COVID flexibilities, you as an E-Verify employer can use the alternative procedure of doing this video chat and making a note in section 2 that you use the alternate procedure to do a secondary inspection of documents. You do not have to, and you should not re-verify through E-Verify any of these individuals.
Yeah, yeah. I know that I-9 and E-Verify, they serve similar purposes, but they're distinct and different. One's mandatory, one's voluntary. Lindsay asked to confirm, let's see, an authorized representative can be the person reviewing the documents remotely. I think while that technically can be true, I don't know why you would use an authorized representative. Like I'm thinking like a notary in a different city. If an HR person can similarly, right, like in your own city, remotely verify those documents, you're technically correct that you could have some like a third party who's outside of your company be an authorized rep who is conducting the review of the I-9 documents remotely. I just think it presents more risk than is necessary. So,
Would agree.
another employer asked, let's see, sorry, if the employer e-verified during the remote inspection timeframe, is DHS stating that e-verified employer has to do a second e-verification? No, they were not saying that. You don't need to do a secondary e-verification. Will the first e-verification between 2020 and 2023 suffice? You are correct. The first e-verify will be enough. There's not a secondary. There was an individual who asked, like, who's qualifies to be an authorized representative? USCIS, DHS have been very broad in terms of who their permitting technically to be an authorized representative is anybody who you believe can adequately and competently complete Section 2 of the I-9. So I would say an adult typically who can look at the documents and reasonably to determine whether those documents are reasonably genuine and relate to the individual. Technically, it could be a family member. It could be somebody physically proximate to the new hire. I have suggested employers not do that because those individuals clearly have a vested interest in that new hire working. So I would not trust necessarily those individuals. Secondarily, any I-9 that is ever completed by a quote authorized representative, HR needs to review extremely thoroughly. I would make sure to have copies of the I-9 identity and work authorization documents and ensure that Section 2 is completed correctly. Sarah, do you want to take some?
I think I don't know that I see other questions. Do you see others?
Let's see. It's hard to
Oh,
kind of send.
I see one that says for e-verify employers, does the requirement to verify documents on a video begin now or 11/1? It begins now, as of October 1st, 2023, when this new form became available. And for individuals that were verified remotely between March 2020 and July 31st of 2023, you would still need to go back and do the secondary like video chat process and make the note in Section 2 of the I-9 before August 30th of 2023 to be compliant.
Um, Another employer asked, remote employees living out of state, can they have a notary verify their I-9 IDs? And Sarah, did you already cover that? Sorry.
Yep, I think I covered that one.
Okay, thank you. Okay, seeing if there's any other questions near the bottom here. We've talked about family members completing Section 2. It's technically possible. I would not advise it. Okay. Let's see. We do have to back and re-verify their I-9 documents, even if they were remotely verified at the time of hire. Sorry, let's
Yes.
see. Okay.
Yeah, I mean, I think the answer to that is yes. So if you're an e-verify employer who remotely verified the individual's documents between March 30th and July 31st, 2023, pursuant to the COVID flexibilities, the guidance has been that you do still have to do the secondary inspection, even if you're going to utilize the alternative procedure, which I grant you is kind of silly and seems somewhat redundant, but this is what's required so far, that you're going to have to do this video chat with the person and then make this notation in Section 2 of the I-9 in the additional information section of that will be in the older I-9s for those, because the new form just came out on August 1st.
Great.
Okay.
Great. I
So
think if there's anyone who your question was not directly addressed, please do go ahead and retype it. Just it's sometimes hard to see within our tiny little screen. See, there will be a copy of this recording for those who want to watch this on YouTube. It'll be there, and I believe it should include a copy of the PowerPoint slides as well. Sarah, do we want to just kind of quickly wrap up the remainder of the slides?
I don't think we have time because we're already 10 minutes over.
Okay.
I don't know if there's anything super important on these other ones that we want to specifically address. This one might be important. Violations and penalties. We mentioned this. I-9 paperwork fines currently are $252 to $2,507 per violation, and those go up per offense. And Roger mentioned that if you are fined for knowingly employing a undocumented worker, then the base fine is around $16,000, and that goes up substantially too per violation.
Great points. Yeah, those are per like worker I-9, right? Not per company. So quickly can add up. You can, on the immigration customs, if you're worried about kind of what is the real world risk there, there's probably about 200 or 300 ICE auditors that are roaming the country, conducting random I-9 audits and investigations. They're conducting thousands of I-9 audits and investigations each year. And so, yeah, certainly that can occur. And some states are actually also getting involved on I-9 investigations as well. Here are practical tips. Let's see. it's critical that whoever you have completing I-9s understands immigration to some extent. And like I recognize that sometimes anyways, it may be somebody signing section 2 who's relatively unfamiliar. Give them a copy of the M274, point them to the I-9 central. So like if they have questions, they can figure that out. If you ever have concerns that something's not reasonably genuine, if I were in your shoes as an HR person, I would not sign section 2. So don't put yourself at risk personally in that situation. All right. Sarah, any last minute tips, thoughts?
I think the one thing I would add is, and we experienced this semi recently with a client who is able to use the alternative procedure and had an employee send documents and did a video chat. And so they noted that the documents that were provided contain many misspellings. So that's something that can be a tip off that maybe documents are not reasonably genuine. And if you see something that seems odd like that, something fishy as the employer, you can ask the employee to provide other documents that are acceptable, either a list A or list B and C. You can't dictate what they are, but you can ask them to provide something else if you don't think that what they've given you appears genuine.
Great point. Great point. Um, well, we're going to wrap up. There will be a follow-up email after this call, just with some of the SHRM credit information and CLE credit information to the extent that you're interested in that. This will be uploaded to YouTube. So to the extent that you have colleagues who would be interested in or benefit from watching this, you can share this with them. If you have additional questions, you can reach out to either Sarah or myself. Our emails are very public on her website, so feel free to do so. Thank you again for joining us on today's call, and we've really enjoyed all of your questions and engagement. And anyways, hope you have a great rest of your day. Take care.
Thank you.